Welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with our Director of Litigation, Chance Weldon, as well as our Director of the Texas Public Policy Foundation's National Election Protection Project, Josh Findlay. Josh, we are so excited to have you on today to talk about redistricting and the fallout from Callais and all of those things. But before we get there, will you just start by giving us kind of a rundown of your resume? I know it is extensive and brilliant, and I'd love to know where you are and how you got to TPPF.
Oh, wonderful. Well, thank you. First of all, it's great to be with you. I am the director of the National Election Protection Project. It's a national election integrity operation that TPPF runs. So we do some work in Texas, but we primarily work in what most people consider the battleground states. So Georgia, Pennsylvania, Wisconsin, Michigan, Nevada, Arizona, Texas, North Carolina. We really run a national operation designed to protect election procedure, primarily at the local level, but really at any policy level that is going to improve election integrity. Prior to coming to TPPF, I was a legal counsel on Trump's 2020 election campaign. I was an associate general counsel there. So I lived through all of the chaos that had to do with election integrity following that election. I ran the president's election day war room out of the White House. And then following that, I was the Republican National Committee's first ever national director of election integrity. So I was doing election integrity before it came cool, and I've seen a lot over the last few years as it's taken prominence in the election landscape in the United States.
And obviously, one of the things that is prominent, particularly right now, is redistricting. So we've got a lot of questions, I think, about where we are at there.
Yeah, can you just give us a quick rundown? And we talked in a previous episode about the Supreme Court's decision with racial gerrymandering in Callais, but can you just give us a quick rundown of how we even got to that under the Voting Rights Act?
Of course. Well, first of all, let me just say there are various ways that you can carve out congressional districts, right? So the court has said that you can create congressional districts based on the partisan makeup of a district. You can base it on existing political lines, so along city boundaries or county boundaries. You can base it on how contiguous, it's the word they use, a congressional district is. They want it to be geographically compact, and you don't want these crazy shaped districts that we see in the past. Interestingly, though, in the past, courts have held that you cannot create congressional districts based predominantly on race. Now, what the Voting Rights Act did, though, was it had a provision called Section 2 that said that you can create a congressional district based predominantly on race if it is correcting past racial injustices. And there were some amendments in the 1980s that said it doesn't matter the intent in creating these congressional districts, but if the effect of a piece of a legislation creating a congressional district diluted minority representation, then that was an illegal congressional district, right? No matter what the intent in carving it up was, if it diluted minority representation, that was illegal. What the Callais case did, this recent Supreme Court case, is it said that you can't make race the predominant factor in creating congressional districts. So what the example from Louisiana where this case took place was following the 2020 census, Louisiana created a congressional map that had just one minority congressional district. The courts said that that's not okay. They had to have two based on the minority population of that state. So they said that even though there was no racially discriminatory intent in creating that congressional district, the effect was that there should still be two minority congressional districts. What this most recent litigation did is it said that second congressional district was based primarily on race. You can't do that when creating congressional districts. And the effect is we have a whole new world in carving congressional districts today.
So if we were just to go back like 2 weeks before Callais was decided, what did the situation on the ground look like? If I was just in a committee that's working on redistricting, what were the considerations at the time before Callais?
Well, so before Callais, primarily in southern states, you had to look at the effect of how congressional districts were carved out. And remember, the Voting Rights Act goes back to the civil rights issues of the 1960s and 70s. What was happening during that time was state legislators were creating congressional districts based on any number of factors, but the effect is that it was diluting the number of minority represented districts in their states. Because of litigation decades ago, there ended up being congressional districts carved out that increased the number of minority representation. So you couldn't, for example, take Atlanta and carve it up so that you'd have a slice of Atlanta, Georgia, but then go out primarily into the rural parts of the state where the voters were presumably more white and dilute the number of minority districts that way. You had to at least keep some of those Atlanta districts together to allow for minority representation. So that's how the maps were carved up prior to this Callais case. From here, it's going to be interesting to see how states kind of attack this issue going forward.
So it's interesting, whenever that started, I guess back in the 1960s, all of Georgia, for example, was Democratic, right? So when you're looking at those districts, you're carving up Democrat districts based on race. But how has that changed with the modern political dynamics? Why are we having so many fights over this now?
Well, that is a really interesting dynamic that a lot of people don't talk about. So you're exactly right. Back in the 1960s, there really was an issue of carving up predominantly Democrat districts to reduce minority representation. The effect was you were going to have Democrat representation either way. The question was it going to be in Atlanta a white Democrat or a black Democrat? That's not the case for the most part anymore in Southern districts. The question now really comes down to, do minorities vote Democrat because they're minorities or because they're Democrat? What the Supreme Court has said is we have to look at the way that these minority groups traditionally vote. We can look at their partisan makeup, but we can't draw congressional districts based on their racial makeup.
So to what extent are we seeing that conversation be rooted in this idea that people of a certain race vote a certain way, and therefore it's okay if we use their race as sort of a proxy for the way that they're going to vote on a particular issue? Is that a conversation that's happening?
This issue gets really interesting, right? So if you look at some of the redistricting that has happened, even just prior to Callais, you look at the California redistricting. I mean, when they drew those new maps that were controversial, Gavin Newsom's maps, right, that got passed, they said that they were carving out those districts to create majority Hispanic districts. They didn't say majority Democrat districts or to add additional districts. They wanted to create majority Hispanic districts. So the discourse around this has been very racially dominated, even if now that is an illegal factor to use in creating these congressional districts. It's going to be interesting to see as courts use the congressional or the legislative record of these cases going forward to examine whether districts are racially based or not.
And as we're having these conversations through the next couple of years, what sort of role do we expect Section 2 vote dilution claims to play in these districts as they're laid out? Are we expecting Section 2 to keep coming up?
This is going to be one of the predominant election fights of the next couple of years. We're in an interesting world now where you don't just win elections. You have to win election process. And as a result, political parties are taking every chance that they can to use the process in their favor. And the new horizon for this is going to be redistricting. We are not close to the end of what redistricting is going to look like before the 2030 census happens. And then I think you'll see a whole other set of fights following that 2030 census. But look, the bottom line is the Voting Rights Act, Section 2, is going to be at the center of most of these fights. There are potentially 70 congressional districts that are going to be affected by this. Now, keep in mind, that doesn't mean 70 districts that one party or another is going to pick up 70 seats. But as you look at the way states could redistrict based on this, up to 70 seats could be affected, netting anywhere from 8 to 10 to 15 seats for one political party. And as close as Congress is these days, every seat that a party can pick up matters. So you're going to see a lot of discourse around this going forward.
Have we seen states jumping to do redistricting following Callais? I mean, we're already in primary season. we just had a runoff here in Texas. So what does that look like on the ground right now?
Well, absolutely. So first of all, Louisiana has had to redistrict based on the results of this court case. Remember, the case was based in Louisiana. The court said they had to redistrict based on this. So Louisiana is going back from 2 minority-based districts to 1. But you've seen things happen in other states, attempts to do this already. South Carolina tried to pass a new map. Their Senate voted it down. Alabama tried to pass a new map. The court said they couldn't do it. Tennessee is in the process of redistricting based on Callais. So you're going to see this going forward. The issue that we're coming into, though, Chance, like you said, is how close we are to the elections coming up. You know, the interesting thing was there were only a couple of states that had not held their primary elections because they wanted to hold off, or primary election filing periods because they wanted to hold off for this case. One of those was Louisiana. So for the most part, the process has moved along in the states. This cycle, you'll probably see a couple of other states try to do things. We'll see how effective it is. But certainly going into 2028, it is going to be a major issue. I mean, just in a couple of weeks, Georgia is going to go into a special legislative session for redistricting, but based on the 2028 cycle, not for 2026.
So on that note, to what extent does the Purcell principle play into it at this point? That being that judges try not to interfere with election rules too close to elections, and they try to let the status quo govern an election. First of all, are we seeing that judges are doing that, or is it something that we're just kind of casting off and judges are willing to overturn election rules even in the days and weeks leading up to an election?
Well, they're not citing the Purcell doctrine yet, although I think every day that goes by, it seems more likely that will come into play. And no, courts absolutely do not cast that aside going into elections. I can tell you that courts are very reluctant to change the rules for an election in the months heading into election. And I think we'll continue to see that here. What's interesting is the standards that they are using these days aren't relying on that. We'll see how long that goes before states face the Purcell doctrine challenges, but so far it hasn't come into play.
Can you explain what Purcell is for those who don't? We're already using that word because we're lawyers, but can you explain what Purcell is?
Absolutely. So it's this principle that says that you can't change the rules of an election too close to the election. And this makes a lot of logical sense because you want to know the rules of a game before you get too far into it. Practically, though, it's a very interesting thing for election integrity because as the election environment changes and you get closer, practices happen, things come up. You know, it's pretty controversial about whether courts should be stepping in and making these changes. In something like redistricting, it's pretty obvious. You shouldn't change boundary lines too close to the election because it affects a lot of things. But essentially, it's that. You shouldn't change the rules of the game too close to the start of the game.
In your experience, how close is too close? Like, what are the factors that courts are going to look at?
Well, that's the $1 million question. That's the question we're all trying to solve, right? And that's why I said it's a big controversy in election law. No one has defined what too close is, and to some extent, it depends on what you're trying to change. Like I said, congressional district lines are a very big change. My guess is that we are getting very close to the point where that change just can't happen anymore. But, you know, in an election law, when it comes to smaller things like voting procedures and stuff like that, it's being litigated constantly what is too close to correct a procedure before an election.
Absolutely. Especially because when you're talking about congressional lines, you're talking about not just the day of who's voting where. You're talking about an entire campaign. Sometimes, you know, somebody announces in June or July for a primary that happens in March. You know, if you go ahead and change those lines in, say, January, it's gonna mess up all of the work that candidate has just done.
Oh, absolutely. And it's not just the candidate. I mean, it's how you run an election, getting ballots printed and picking polling locations and things like that. There are a whole factor of issues that go into it. And
the Purcell principle applies even, like you said, to things like the day of procedures, right? What is law and who can vote remotely, for example, who can do a mail-in ballot, those kinds of things. Also, the courts have used the Purcell principle as well.
That's exactly right.
And not to bring up old memories, but a lot of that in the 2020 election fights, that became really important with a lot of these procedures at the 11th hour. And maybe some of those examples could kind of shed light on how Purcell works, or if you have any war stories on that.
Well, absolutely. So 2020 was the perfect example of how I think Purcell should work even better. If you remember, that was COVID, right? Right in the middle of COVID, and states were changing their election rules last minute, and they were making changes that they just didn't have the infrastructure set up for. So if you remember, places like Pennsylvania were going to all mail-in ballots, but the counties did not have the infrastructure set up to process hundreds of thousands of mail-in ballots. So you remember places like Bucks County where they had absentee ballots just stacked floor to ceiling in a room. They couldn't be processed. There was no security around them. This led to a lot of those questions about what happened in that election because the infrastructure was just not set up to do those things correctly. You looked at other kind of the crazy voting practices, ballot collection practices that people put in place, the 24-hour voting, the drive-by voting, the drop boxes that were unsecured, right? Just kind of cardboard boxes out on the side of the street that once you put a ballot in, there was no challenging it. Things like this were implemented. What was fascinating is courts during COVID did not rely on the Purcell doctrine at all. They said these are, first of all, the problem is they just didn't hear cases based on this, right? I think that was a big issue during that election cycle. The other one was, though, that these are different circumstances, so we're going to defer to emergency powers. What you saw, though, was it created chaos. It created distrust in the election process and a lot of mistrust in the election results that in a lot of ways we're still recovering from. So when it comes to redistricting, depending on which side of the political aisle you're on, you want courts to either hurry up and decide these cases or not. But either way, from an election protection perspective, we need definitive rules. Otherwise, you're just going to have another case where there's mistrust in the election process.
Absolutely. Absolutely. So let's talk, if you're willing to, I'd like to dive into some of the specific states that have had fallout from Callais itself. Starting with, I think importantly, Alabama. There's been a lot of weird things that have happened in Alabama in the last couple of months. Can you help us get into some of the nitty-gritty in that state and the weirdness that's happened there?
Sure. So in Alabama, again, Section 2 applied primarily to southern states. And the reason for this, if you remember, was because during the 60s, they were drawing congressional districts that were racially based, and courts said they were diluting racial representation, minority representation based on race. So this primarily affects southern states. Following the Callais case, Alabama was one of the first states to pass a new map, to do some of this mid-decade redistricting that we've been talking about. And the courts struck it down right away. They said that we're not ready to make this change yet. And so we'll see what happens going forward if there's anything they can do. But that's where that case stands right now.
So the way things are in Alabama right now is they still have this arguably racially gerrymandered map that they're going to have to continue under for the time being. Is that correct?
That is correct.
Okay. And then just as a side note, I guess, because it's not really a Callais problem, but what's happening in Virginia?
So Virginia is not a Callais problem. It is a redistricting issue, but a very different redistricting issue. So what happened in Virginia is the legislature used their kind of citizen initiative program to put new congressional districts on the ballot for the citizens to vote on. What they wanted to do is redistrict several districts to create more Democrat districts. The citizens passed this. It actually went forward. It went on the ballot. Citizens passed it. However, the big issue there was, and this was before the Virginia State Supreme Court, that when the legislature put this on the ballot, they didn't follow proper constitutional procedures. Specifically, there is excuse me?
Under the Virginia Constitution.
Under the Virginia Constitution, that's right. So specifically, there has to be a set time between when the legislature votes on an issue and it gets on the ballot for the citizens. The legislature, when they went through this process, did not provide enough time for that. And so the Virginia Supreme Court struck it down on state constitutional issues because they violated that time period.
And in Virginia, was that a situation, and I don't remember the exact count, but it was creating more Democratic seats. I mean, what did that look like on the ground? Do you know what the shift was for that redistricting?
It was creating more Democrat seats. I think it was creating 5 additional Democrat seats. So this was going to be a significant win for Democrats if it went through. This was not one of those small 1 or 2 seat redistricting cases. And like we said, the margins are so small that everything matters. But this would have been a massive win for Democrats if it would have passed.
But at this point in time, Virginia is operating with its old map and Republican dominated, I think. You probably know better than I do.
Not Republican dominated, but better in favor of Republicans. And no,
we have
this one has ended, right? So this one went to the Virginia Supreme Court. I think there was an emergency appeal to the United States Supreme Court. It failed there. And so this matter is settled in Virginia for right now.
So I have a question that's for both you and Chance, because I think you'll bring different answers to this, Josh. I'm curious whether you believe that Callais clarified the law or made the law on the ground more complicated and less flexible in application. Chance, you want to take that first?
Oh, I don't want to take that first.
Go ahead, Josh.
I'll defer to our election lawyer.
Well, so it's interesting, right? I'm going to use some terms that you'll hear in the news. First of all, what the Supreme Court case did not do is it did not gut Section 2 of the VRA, right? Which means it didn't eliminate it completely. It just said race can't be the predominant factor that you use. Theoretically, I guess that means you can still use it as a factor, right? Along with political makeup, like I said, existing political lines, things like that. We still need to see what this looks like in practice before the courts, though. And we know that this is going to be tested. Like I said, there is going to be a lot of pressure from the White House on states to redistrict based on this. But then also, I think, interestingly, you're going to see a lot of backlash in blue states where they are going to try to create more congressional districts, potentially based on racial lines, although my guess is that using the California example, they'll use partisan language going forward. But it's interesting because it didn't gut Section 2, which means theoretically it's still in play, but we need to wait and see how this plays out in the courts.
Yeah, I think it really just, a pure racial gerrymander has always been theoretically unconstitutional anyway. And I think what Callais says is you really have to disentangle politics from race if you're going to judge a gerrymander. There has to be some real evidentiary burden to disentangle the two. And I think that's going to be really hard to do on the ground, and we'll see how it plays out. But I don't have firm predictions on how that'll play out in practice, but I think you're going to see a lot of litigation over it.
So the way the court read Section 2, like you said, Josh, the court didn't gut it. It didn't gut Section 2, but does it essentially render Section 2 a complete overlap with the 14th Amendment? Does it create a situation where Section 2 just echoes what the 14th Amendment already demands anyway?
I think it basically does, but I think that's what we're going to wait and see. Again, we're going to have to see if there's any practice, if there's any distinction in practice, right? I mean, I will tell you right now, the way that, these predominantly Republican states that are trying to redistrict under this are operating as if Section 2 doesn't exist anymore. We're going to see if courts carve out something, that changes that going forward. But they're operating as if it has been gutted, even though technically the words on the page don't say that.
Yeah. If you had your crystal ball, where do you think we see the future challenges in this area first from a litigation perspective and then from a legislation perspective? Where do you see this going?
Well, if you're talking, first of all, if you're talking the amount of litigation, I think you're going to see a lot of it going forward. These obscure redistricting experts on both sides of the aisle that have not been prominent recently are going to gain a lot of prominence over the next couple of election cycles. So I think you're going to see a lot of litigation. Geographically, I think it's primarily going to be in the South. Like I said, these red states that have been operating under Section 2 for a long time. It's going to be interesting to see what happens in the 5th Circuit and in the 11th Circuit. And then I think you'll see spillover litigation. And this is the part that we don't know what's going to happen. I think you'll see spillover action and litigation in some of these blue states. And so like I said, we're in an era where you have to win the election process. And redistricting is now part of that process. As much as, some states wanted to pretend that they could put bipartisan commissions in place or whatever it was,
Right.
I think those days are over. I think now you're going to see full-on fights over the way we carve congressional districts out going forward.
So are we living in an era then where we redistrict every single cycle, every 2 years, we're dealing with new districts? Or do you think this will settle out at some point?
Well, we're in a state in a lot of ways in this country where we're in unprecedented territory. And I think that's what we're looking for. Now, look, every 2 years might be a lot, right? Because you would run into that Purcell doctrine. But, right now we're talking about mid-decade redistricting, theoretically on, the sixth-ish year. We're in 2026 right now. But could it be more often than that? Absolutely. And I think you're going to see states that will test the limits of that going forward.
Are we going to run in, this is more probably of a question for Chance, are we going to start running into tyranny of the majority problem, do you think?
I mean, it'll be interesting. It'll be interesting to see how it shakes out, because one of the problems with election law, and I know that Josh can speak to this, is a lot of times, because the quick turnaround, and because of Purcell, sometimes a case is not ripe until it's moot. By the time you litigate it, you're already too close to the election by the time it gets to the court. So Purcell applies. And then once the election's over, the court will say it's moot until the next election with a lot of these election law cases. So once you start pushing it that far, you start to have a real problem with getting courts to rule on these things. And I think maybe that won't be the case with the redistricting, but who's to say?
So Josh, he kind of name checked you. Have you had a lot of issues with your cases or cases that you're familiar with being mooted before they're able to be heard by the court?
Oh, absolutely. It's one of the fundamental problems with election integrity law right now, right? So the clearest example of how this happens is you want to litigate over election procedure that gets put in place for an election. Well, courts say that there's no harm in that procedure until the election happens. And then the election happens with that procedure in place. And afterwards, there's no point in litigating because the election's over and done with. It is a fundamental problem of election litigation and election law right now.
And because I would be remiss in a rightly decided episode without bringing this up, do you also see standing issues in bringing these challenges?
I do. And there are always standing issues when it comes to election integrity cases. Now, look, the United States Supreme Court is getting better on granting standing to more entities. But yes, and until things change, there are always going to be standing issues when it comes to election law cases.
I think just this year we got a pretty good standing case. Was it Bloss that just came down?
Yeah.
We did. And interestingly enough, this will be shocking to a lot of people, but it granted candidates standing. The view before this was that candidates didn't have standing for the most part in their own elections. It's kind of insane. But this tells you where we are in standing laws when it comes to election integrity, that just now candidates are getting standing in their own elections.
In the year of our Lord 2026, a candidate can sue over the practices in his own election. Yep. It is hard to imagine a clearer case for standing than an actual candidate in an election. But here we are. At least that much is settled. Final thoughts from both of you. I'm looking for maybe some hope, maybe some definitive something about where we're headed in the future in the fallout from Calais. Chance, just start with you. What can you give us some hope on how this is all going to shake out?
There's really two things at issue here. One, politics is gross, and it's always going to be gross. It's always going to be a certain level of blood sport. But on the other hand, I think, Justice Roberts had put it well many years ago when he said the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And so at some point, you had to rip the Band-Aid off. And we're just dealing with the other side of that equation now, that politicians going to be politicians.
Yeah, absolutely. Josh?
Well, I'm not filled with quite as much hope yet. Now, here's what I think. I think that going forward, like I said, election process is the fight. Not only do you have to win at the ballot box, but you have to get the rules in your favor. And the new frontier, for the next, at least through 2030, is going to be a redistricting fight. And so we have to be prepared for that on all levels. I think, though, if we are looking for something positive, And I think, to echo what Chance said, I'm hoping that the discourse around the congressional districts becomes less racially based, and we focus on the issues that are important to people, that we stop categorizing people based on race, and at least let's look at the partisan makeup, the policies that are important to people, and see if we can get a more fair process going forward.
Excellent. Well, Josh, thank you so much for your time, and thank you for joining us today. For our listeners, thank you for joining us for Rightly Decided. If you've enjoyed our conversation today, please leave us a review and join us next time for more Rightly Decided.